ನಮಸ್ಕಾರ ಸರ್. ನಮಸ್ತೆ ಸರ್. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್? ಓಕೆ, ನಿಮ್ದು ಮ್ಯೂಟ್ ಆಗಿದೆ. ಓಕೆ ಓಕೆ. ಮರ್ತ್ಬಿಡ್ತೀನಿ, ಮತ್ತೆ ದೊಡ್ಡ ಮರುಪಾಠ ಇದ್ದಂಗೆ ಇದೀನಿ. ಬೇಕು ಕಾಣ್ತಾ ಇದೀನಿ ನಾನು. ಏನ್ ನೋಟಿಫಿಕೇಶನ್ ಅಂತ ಕಾಣ್ತಾ ಇದೆ. ಡಿಸ್ಕ್ರೈಬ್ ಇದು ನಾನು ಅದು ಕೋರ್ಟ್ ಬರ್ಲಿ ನಾನ್ ಬರದ್ ಬೇಡ ನಾನ್ ಚಿಕ್ಕದಾಗೆ ಬರ್ಲಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮ್ಯೂಟ್ ಇದೆ, ವಿಡಿಯೋ ಕೂಡ ಕಾಣಿಸ್ತಿಲ್ಲ.
Yes. Yeah.
I'm moving a memo. This is concerning a case where there is a wrong date. Yesterday, my colleague moved this memo. Your lordships had asked us to intimate the opposite counsel. We've intimated on mail yesterday.
I'm here online. What my friend is mentioning, we had earlier sought for a date of 26th, that is tomorrow. It can be put for tomorrow. I have no difficulty if that is
Sure.
what she wants.
I have served an email also and I'm filing a mail.
No difficulty, man. I was grateful.
Much obliged. That was a wrong entry made, my lords.
Both the councils are okay with tomorrow?
Yes, my lords, we are fine. Great.
Much obliged.
Grateful.
2023, Madam Elats, the court had directed, given a direction with respect to visitation rights of the child. For every other day it's being violated, there has been some turbulence from the mother's side, my lords. The husband is not provided, is given the child on weekends and during the vacation. I've filed an IA for direction. The matter may be taken up on Tuesday tomorrow.
What direction?
For with respect to the visitation of child, visitation rights for the child on weekends and during the vacation. And it's been violated repeatedly, my lords.
Orders passed for visitation
Yes,
during
my lords.
weekends and vacation?
Yes, my lords.
And what further you want from this court?
My lords, they're not, the mother is not giving the child on the weekends and during the vacation.
Now in Madrid.
Well, it's filed another year for direction, my
In
lords.
direction.
to direct the respondent to give the child during the vacation.
If
And
they violated, go and do what is
now,
required,
since summer vacation is coming,
what you are supposed to do. If they violate some order of the court, what you are supposed to do? File application for direction.
let's, despite the matter is still pending, my lords. There,
ಹೇಳೋದು ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ ನಿಮ್ಗೆ.
I understood.
ಏನ್ ಮಾಡ್ಬೇಕು?
I'll have to go before the trial court and see.
Huh?
I'll have contempt. I have to file.
Go file contempt.
Permission, my lord.
Yes, Mr. Prasad.
16.123, my lord, is a parted matter.
Mr. Counsel, whether the child is taken out of the jurisdiction of the court. They are in Bangalore.
Bangalore.
So summer vacation has started.
It's coming over, man. The child is a special child. She has autism.
The child is going to school,
Yes, my lord. She's going.
special school.
Yes, yes, my lord.
So initiate, and if you don't
And
succeed,
also, my lords, the address of the she has relocated the child also, my lords.
Hmm.
So they're not living in the same address and they're not provided the fresh address as well.
then that's the case, go and do what is required as per law.
Order list, my lord, with permission, that's why. 16.123, my lord, is a parted matter. Already 10 times it's already heard the matter.
ಯಾವ್ದ್ರಲ್ಲಿ?
16.123.
16.1.
16 is concerned, my lord, this is a fresh matter. And 16.123, for example, my lord, is a parted matter. Maybe dealing with the 16.
My lords, I am for the petitioner in the first matter and the respondent in the other matter, my lords. It was parted in the sense there was conciliation proceedings in the chamber, my lords. Other than that, there was never a hearing before the court. Now it is posted, now it was posted for hearing on. Sir, let me complete my submissions.
ಅವ್ರೇನು submission ಹೇಳ್ಬಿಟ್ಟು. ಒಂದ್ ನಿಮಿಷ.
Only
ಹೇಳಿ.
there was an attempt by the honorable court to see that whether any conciliation or settlement is possible between the parties. That is the reason it was taken as parted. If your lordship kindly sees, even the parted is taken in the chambers. So there's absolutely no hearing in this case. It is done on 2/4/2024 in the chambers, my lords. My lords, the fresh matter is before your lordship and also as per Rooster, my lords, the other matters has to come before your lordship. And now it has been posted before the court on merits because there was no conciliation, there was no settlement between the parties, my lords. Hence, my lords, I moved the memo before this honorable court and your lordship allowed the memo, my lords, and hence it is posted before your lordship. Lords, there was never a hearing there, my lords.
16.123 is concerned, Lord. Already heard the matter of the other bench. And today it's fixed for day. To avoid that, my lord, more than 10 hearings, it's taken. Kindly see the order sheet, my lord. And after that, my lord, they filed one more petition saying that, my lord, it's a connected matter. It's a parted matter, it's not at release.
What is order sheet? So this
That's why, my lord,
16.1. 16.12 and 3 was part heard before the other coordinate bench.
Please, ma'am.
It was addressed, arguments were addressed.
Yes, my lord. I already argued the matter and so many hearing dates, my lord, their conciliation also.
And why it is listed before me here?
My lords,
Because
it is not,
16 is concerned, my lord, they filed a fresh petition.
my lords, arguments are not
Okay,
addressed,
Amma.
my lords.
You completed, no? You
Yes.
didn't want him to interfere,
Please, ma'am,
so you don't interfere.
please.
16 is concerned, my lord, it's a notice not at, it's a fresh matter. Once it's a parted matter, it is not at release. That's why, my lord, it may be dealing with the 16, my lord.
Let us see the order sheet. In 12 WB. ಇರಲ್ಲ. 16, 12. Where is it part heard?
It's a part of mill.
No, whether the court is,
Yes, madam. It's stated as a part of 16 point last.
date, ಯಾವ date ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ? When is it part heard?
The part at least in the Millard is a
No, when it was part heard?
date, is more than this, it's coming under the part at least only Millard, last.
ಯಾವಾಗ? Somewhere around 24, late 24 December or earlier to that?
No, Millard, last week, come up, last week, Millard, it's in the part at least only, but, order sheet, Millard, I don't know. It may be dealing with 16 Millard.
Yes.
I don't know, this 16 matter is concerned, I don't have any idea about what is the matter and all.
Yes, it is already part heard.
My lords, it was only, as my lords, I made a submission, it was only in chambers for conciliation, my lords. There was never hearing on merits
That you go and
before
tell the
the
other court.
open court, my lords.
That you go and tell the other court. Post this matter on
My lords,
21/10.
your lordship may kindly pass.
Did you
over the
hear
matter.
me?
Yes.
Post this matter on 21/10/24 as part heard. This is the order dated 18/9/2024 in all the three cases.
My lords, on 2/4/2024, my lords, first it was in chambers, my lords, in 4987, my lords. 4987 of.
4987, 1912, 20817 are all taken up together. 18/9/24, it is part heard.
My lords, but it is in chambers, my lords, if your lordship may
Stated
kindly.
in chamber is not court.
My lords, it is for conciliation is my submission, my lords.
Perfect. D-link 16.1, 16.2 and 16.3 as wide order dated. (18/9/2024). The coordinate bench has listed the matter as part heard and to be posted on 21/10. Full stop.
Lordship, if one submission, my lord.
Yes,
My lords, party has engaged the senior counsel, my lords, the matter may kindly be passed over for his submissions, my lord.
yes, sure, pass over. For 116, for 16, it will be passed. For other three matters, it is part heard, dealing the matter.
My lords, for all the matters, my lords, because he's
Alright,
arguing
want
in
this
all.
order to be passed in presence of the senior counsel, I'll pass it. Come. Yes, next, Karim.
Adjournments page wise, page number 8, seal number 34. Page 9.
My lord, serial number 34, my lords.
34, yes.
My lord, some inconvenience for my senior, my lord. I pray for an adjournment, my lord. Pray for a week's time, my lord.
Who are you?
I am for the respondent number 2 in this case, my
Learned counsel for the respondent, Kailash Shankar.
My lord, we are informed through a message, my lord.
Informed. Counsel for respondent 2 seeks time. Call this matter next week.
Page number 9, seal number 35 to 39.
Yes.
Page number 10, seal number 40 to 49. Page 11, 50 to 54. Page 12, 55 to 59. Page 13, 60.
Sorry, my lord, sufficient, that released matter, my lord, maybe this one date, my lord.
No, it has to go before the other court. Non-date kodak baralla. It will be placed before the bench,
Please.
which had heard the matter.
Please.
That you can move that court, that will give a date.
Please.
Or list this matter, madam, give a date. Huh? Have Correct, 1, 2 and 3. Give a date for the first week of April, somewhere 3rd or 4th.
Please.
3rd and 4th ಕೊಡಿ ಅದರಾದ್ಮೇಲೆ ಅವರ ಮುಂದೆ ಏನು ಮಾಡ್ತಾರೆ ಮಾಡ್ಕೊಳ್ಳಿ. 3rd and or which date you want? 3rd?
Third,
3rd is okay.
please.
3rd. In the meanwhile, if she wants to make some submission, let her make through some senior counsel.
Yes, please.
If you are busy, you can send your colleague.
Please.
List one for being spoken to, serial number one.
Happy for the petitioner in this matter, my lords.
Yes.
Your lordships had your lordship had directed us to submit the document. Yesterday I have served them the copy yesterday afternoon itself, and I have filed it. Now they are filing theirs, serving me just 5 minutes ago, my lords. But we are in consensus with those things, my lords. If your lords may have my being spoken to first point, my lords, there are 3 points for consideration, my lords, being spoken to. I didn't know how to put it in words, my lords. I've put like the way that will be easy for your lordships. At page 2, if your lordships can see, point number in the operative portion of the order, point 6 is what we are looking for clarification, my lords.
Yes.
At the second para, I have highlighted the deleted and addition, which are in bold, my lords. So what we want that to be is the petitioner father shall have the custody of the minor child for the period of 15 days commencing from the last day of the school. On the completion of the 15th day, the petitioner father shall hand over the custody of the minor child to the respondent mother, who shall have the custody rights from the next 15 days. Thereafter, any other remaining part of the vacation, the petitioner father shall have custody of the minor child for the first half of the remaining period and shall hand over the custody of the minor child to the respondent mother for the second half of the remaining period. And also, my lords, this year, because the birthday was coming up, we've made it at 2 p.m., my lords, because she wanted to celebrate the first half of the birthday. That may not be the scenario on any other summers also. So if it could be specifically stated that the father can pick up the child at 9 a.m. and drop back at 9 a.m. on the 16th day morning, that will be convenient, my lords, in terms of the time. Because
that is in the regular visitations.
Regular summer vacations. This is in respect of summer vacation, specifically that point is, my lords.
All right. So picking up the child from at what time?
9 a.m. in the morning. On the
How
first.
old is the child?
For 4 years old, my lords.
Still get up at 9 a.m.
The child goes to daycare center at 9 o'clock. So it leaves house by 8:30.
In vacation is going.
My lords, vacation only for pickup is at 9, my lords. Only one day. Then the child will be.
Yes, what did you say?
Your lordship, first of all, this memo for being spoken to was moved by us and they had made a hue and cry about it. Having said that, I'm glad that at least we are able to reach some consensus on few aspects. Our main concern was, your lordship, the 40th birthday of the mother happens to be on 29th March. And this was made as a submission, and that is considering that this honorable court had directed them to pick up the child on the following day, 30th.
At 2 p.m.
But at 2 p.m.
That somehow was not recorded in the order sheet.
Sir, petitioner father shall have custody and visitation rights of minor
what
child
happened,
on 30th March from 2 p.m. onwards.
Yes, but what happened was he started sending emails thereafter saying,
Well,
that I will pick up the child on 29th after the annual vacation. So that is why I had to move the court.
My lords, I have the email.
Not mention that, because ideally 29th March being Saturday was his visitation day. That is why we had moved the trial court also to alternate that with any other day, so I can take the child for my 40th birthday. But since that categorically did not come that on 28th 9th, I will have the access to the child. He has sent a mail saying that that also happens to be the annual day of the child. So he says that I will pick him up after the annual day celebration, as if none of this was discussed.
My lords.
So that is one. Ma'am, please let me make my submissions. This was one of the reasons that we had to move the court. Apart from that, your lordship, there has been a dispute now on the drop-off time, pick-up time. We don't want to get into that. Ideally, if this honorable court fixed up a particular time for pick-up and drop-off, that would ease out the disputes between the parties regarding it. Otherwise, this will keep going on what time you're going to pick up, what time you're going to drop off the child. It can be any time which this honorable court is thinking is conducive for a child of 4 years old. We are okay with it. If this honorable court says 10 o'clock or 11 o'clock or even 2 p.m., we are okay with it. But let a time be fixed.
All right, we'll fix it.
If your lords may have, I have taken a
Have
second.
patience, madam. Patience, let her complete.
We are okay with their proposal that the first 15 days of the school vacation, he can have it. But let that be specified that it starts from the day of the school calendar. School will anyway issue the holiday calendar year on year. So whichever is the holiday on the first day, let them pick up the child at that particular time. Because they have made it far more complicated by saying any weekend preceding that he will have access. Now, my humble submission is that out of 4 weekends in a month, I get only 1 weekend with the child. If that weekend somehow happens to be along with the holiday, whenever the holiday starts, I lose that also. So let it be on record that the holiday calendar will be issued by the school on the first day when the holiday is starting. Let him pick up the child. I have absolutely no concerns. The timing of the call, Your Lordship, there is one aspect Your Lordship has been indulged in giving us access to the child over the call. I want to actually limit to only 15 minutes because I have reduced always the screen time for the child over the phone. And I see the during the calls with the father also, he does not sit in one place for more than 10-15 minutes. So I am also not going to force it on the child. I only want to limit 9 a.m. to 10 a.m. any time between that. So 15 minutes, I need to be given access to the child.
Yes.
My lords,
What is given by the court?
my lords, if your lords may have in respect of
It has
timings,
mentioned the
it is at
timing.
page 3 in my, it's at point 9, my lords, in the operative portion. I have mentioned that in page 3 also. It is mentioned
How much
12
time is
p.m.
not-
to, time is not specified, my lords. Between 12 p.m. to 1 p.m., both of us are okay between 9 a.m. to 10 p.m. And we are requesting for 9 a.m. to 10 a.m. And we are requesting for 30 days because it's the 30 minutes. Because the child is used to 30 minutes. My learned friend is making some submission saying that the child would not be in front of the phone for 30 minutes. The child is 4 years old and it always has amazing conversations with his father for half an hour. So we are okay with 9 a.m. to 10 a.m. that they have also proposed, which I have written at point 2 in page 3, my lords. And my lords,
I'm
in
insisting
respect
on
of
only
point 3, my lords, that I have mentioned in page 3,
Yes.
that is in respect of weekend, my lords, what my learned friend mentioned. My lords, I'm a non-custodial parent. I get minimum little amount. All that what I'm trying to say is Saturday and Sunday, if it falls before or after the vacation, obviously it is called vacation. The vacation starts from that day and ends in that day. That being the case, in fact, I am telling to be adding that in the vacation period itself so that equally it can be shared. Technically, she will also be getting 1 day more if that preceding 2 days, Saturday, Sunday is added. Because the child has a daycare and now child is going to preschool, which has only 5 days. So the Saturday, Sunday preceding and after will only add to the number of days, which will make life easy for both parents. And my lords, in point 3, I have asked for one request that I have requested before your lords, that the Aadhaar card of the child, earlier the respondent had accepted to give one copy of the Aadhaar card because I'm making travels, I'm booking flights, I'm doing hotel bookings when I'm traveling. I do not have the Aadhaar card one set. The duplicate of the Aadhaar card is 100 rupees and it will come in 2 days. And I have been requesting for the last 1 year and she's not giving that. That one request I've put, my lords. If this lordship is convinced on that, it can be, my lords. And on the third point, the third thing that I've mentioned is that Dashara, which they are also agreeable, being a non-custodial parent, I get the choice of choosing which first half or second half that I can choose as per the CRI Foundation and by the Honorable Supreme Court, where it says the non-custodial parent get to choose which part of the vacation. Now that we have fixed summer to be first for the father and second for the mother, in respect of this winter, Dashara and Diwali, I will be intimating them at least 3 weeks in advance, which whether the first part or the second part that I would be taking. And Dashara, Deepavali and winter being small vacations, I'll pick the child at 9 a.m. and drop the child at 9 a.m. This 2 p.m. was only made as a special circumstance, considering it's the 40th birthday of the respondent herein. And my lords, these are things which could have been sorted out amongst us. My client had simply sent out a mail about the annual day, which
All
was
right,
on
please
20.
don't start arguing. This is not a review petition.
My lords, I have put my brief.
Sorry.
I have one concern regarding the second half of the choice of which half. My reason is that child is school going as he's growing older. And if we have to make this into a concrete order, which will continue for a while, we need to ensure that the child is least inconvenienced. My humble request to her and submission to this honorable court is, let him take the first half, I'll take the second half. Why? Because this will enable him to again adjust to the school going days. Instead of being dropped off one day before the school starts, it is again inconvenience. And again,
Now the
My lords, it's a 4 days
Differences.
holiday. I don't know for 4 days holiday, why such a submission is made.
now what is
Because-
required to be corrected, which you want is
Point one,
time period for talking.
yes, my lord, that to be from 9 to 10 for 30 minutes.
that's 15 minutes is what I'm insisting.
Then pick up and drop.
9 AM to 9 AM on all future summers and future winter
At
summer.
what time?
9 AM to 9 AM for all future summer, winter, Dashera and
9 AM
vacation.
to 9 AM.
Yes, my lords, because this time 2 PM was a special circumstance, that's all.
All right. Then first half, apart from the summer vacation and winter vacation, is Dasara and other vacations which are smaller.
The
first half
father get to choose, but he would intimate at least
now to be decided.
Your
But-
lordship, that may be, yes.
And
at least 3 weeks before he would intimate the choice.
please listen to the order of the court. You made your submissions. Parties to the Senate counsel for the petitioner and counsel for the respondent have filed a memo under the caption for being spoken to for seeking certain clarification with regard to the timing of the visitation rights and custody rights, the pickup time and drop time, apart from the summer and winter vacation, the other vacations declared by the school for the purpose of sharing between both the parents. And with regard to audio and video calls, a time to be prescribed. Full stop. The request made by both the councils appear to be genuine, as the order does not specify with regard to these aspects. So custody and visitation rights are given. For the summer vacation and the winter vacation. So therefore, in continuation of the order passed by this court, dated 25 February 2025, the order would read as under. With regard to the summer and winter vacation, 50% shall be shared by both the parents equally, which are already stipulated in clause para number 6, Roman 6.
My lords, in 6, my lords, it is mentioned that after 15 days, it will be the mother holding on to it. That has to be changed to 50%. Remaining, whatever is the dates, they will share equally. That has to be made, my lords. In fact, your lordships may have at my page 2, it is clearly mentioned. I have striked off and added for the sake of convenience, if your lordships can see in my.
Now, the 50% sharing, there is no dispute.
My lords, they disputed. I have put the email. If your lordships can.
50% you are going to share anyway.
My
That is the order of my. That is the order of
They
the
did
court.
not agree, my lords. That's why.
Who did not agree, ma'am?
My lords, I shared the remaining dates. They said the order is only for 15 days, 15 days. The remaining days I will not give you. That is what the email is. I have added the email at page 5, my lords. She says the remaining days I'll not give because the judge is told the remaining dates I will hold it. Because that's how it is actually mentioned, my lords.
It reads is, shall have petition, father shall have custody for a period of 15 days. On
Correct.
completion of 15 days, father shall hand over custody to the mother, who shall have the custody for 15 days.
Yes, my lord.
Again, thereafter, father shall have visitation rights for next 15 days and hand over
Huh.
the custody of the child for
Yeah,
the remaining
because it
part of
says
the
all
vacation.
remaining days.
to
There,
the
what happens is, my
respondent
lords,
mother.
sometimes they have 78 days. Sometimes they have 80 days. If that's why I only want minor correction, my lords, wherein it says that the remaining will be shared equally.
All
That we are okay, Your Honor. They wanted the
Correct.
majority of the remaining.
Therefore,
days.
in addition to clause 6, apart from what is stated, in addition to the vacations that are already provided, if any further vacations or holidays of the school exist are declared, the same shall be shared by both the parents equally at 50% each.
With the last portion of the
So
vacation.
the last
being with the
portion shall be given to the
My lords,
mother.
last portion anyways, she's going to take the second half. If we write that, that will become confusing. Anyways, the second half is she's holding on to it.
Again, if there is no clarity, Your Honor,
Got it.
again, they will
Next.
insist on the last portion. Let there
With
be.
regard to the clause 5, this court had stated that the father shall have the custody of the and visitation rights of the minor child from on 30th/3/2025 from 2 p.m. onwards. This shall be read as the father shall have custody and visitation rights from 30th.
Not 30th, my lords. My lords, this 30th part, which is written in 5, is correct, my lords. That is only applicable to this year. In 6th, if you're lord, that applies to all future.
30th from 30th March 2025 from 2 p.m. onwards for the present summer vacation.
Yes.
Yes,
This 2025.
yes, my lords.
Full stop.
My lords, on
For
9,
clause number
the
9,
timings.
this
is-
code had permitted the father to have access to the minor child and also the mother for video and audio calls between 7 p.m. to 8 p.m. Now both the parties submit that
9
they
to 10.
would be comfortable between 9 a.m. to 10 a.m. And the period of call shall be restricted to 20 minutes by both the sides. If the child wants to talk, it is the option of the child that it can continue further.
Much better.
Full stop.
And my lords,
Next.
one addition was proposed, my lords, at my page 3 at point 3, my
It's
lords.
also made clear that the first half of the vacation shall be spent by the father and the second half of the vacation shall be the child, these shall be spent with the mother. Child shall spend, rectified. The minor child shall spend first half of the vacation with the father and second half of the vacation with the mother for the remaining part of the vacation and holidays, if any exist. That's all.
Your Lordship, her birthday, that may be mentioned. That 29th normal visitation day
My lord,
stands cancelled.
That
in
cannot
lieu
be
of her-
made as a rule for every year, my lords.
Not every year, this year.
Today, okay, my lords,
Now, when I have already said that he will have from
for this year, it is mentioned that he'll have it.
That 40th day birthday celebration is on 29th, so his regular visitation on that day is standing cancelled. That's all I want, because what would happen later on, they will.
whose
be
birthday is the
Mother's.
Mother's
40th
birthday.
on 29th of March.
9th March.
Barcode. The visitation rights of the father on 29th March
2025 specifically, my lords, because I don't want them to do it as,
shall stand suspended until otherwise further ordered by this court for the present and future.
my lords, if the vacation, my lords, then my birthday is on January. I always file an application and get my birthday. They don't even allow.
You take it on your birthday.
Then that be mentioned, my lords. My birthday, at least I be allowed to have access with my
It's your birthday.
4th of January, my lords.
Is that a vacation day?
My lords,
Is that a vacation?
but here, what if the school is there, then if I have a visitation on that day, she will mandatorily not give me the visitation. Now already today, now this Saturday, 29th of March is the annual day. If I was never allowed to skip the child for one day for few minutes of the daycare center. She is ready to skip the annual day and go. Whenever I skip even for few minutes, she would send long mails. Now that being the case, an order like this means that every 29th, when I have the first half of the 15 days, if the 29th falls between my first half, I'll have to bring back the child to Bangalore and make
Vacation starts when?
my lords, as of this year, it starts 30th.
Make it 29 for this present year. You file whenever you want, you file.
Yeah, much.
You want to persist and keep the litigation alive forever.
This could have been spoken between the councils. In fact, my lords, last Monday, they moved the memo. Your lordships directed them to serve the copy. They did not even serve me the copy. No. Most obliged.
For orders, serial number
I shall
2,
not.
Chantraj K.
Shantaraj. Week's time, needful done notice to R1 and 3.
Number 3,
My lord, I am for the appellant, my lord.
Insufficient.
number 1.
R2.
My lord, in this appeal, my lord, insurance company has filed the appeal challenging the liability on the ground that dishonor of check. Check is dishonored and policy is cancelled. Therefore, my lord, permission to release of the amount, my lord, cannot be.
Await service of notice
My lordship.
of R2. Have you deposited the amount?
My lord, I'll get the information. I inform the insurance company. Probably they have deposited, my lord. I'll get the
Await-
information and
await
file them.
notice of R2. Call next week.
number
But-
4,
Mission ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಸ್ವಲ್ಪ. They have produced the documents in R1 to R5. Have produced the check ಒಂದು ಕೊಟ್ಟಿದ್ದಾರೆ, ಆಮೇಲೆ ಬ್ಯಾಂಕ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಆಮೇಲೆ ಅದು ಚೆಕ್ ಲಿಸ್ಟ್ ಬೌನ್ಸ್ ಆಗಿರೋ ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಆಮೇಲೆ ನೋಟಿಸಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. They have not produced the postal receipt and acknowledgement. On the main ground ಮೇಲೆ ಬಂದ್ಬಿಟ್ಟು ಇವ್ರ ಅಗೇನ್ಸ್ಟ್ ಮೇಲೆ ಕಾಂಪನ್ಸೇಷನ್ ಅವಾರ್ಡ್ ಮಾಡ್ತೀವಿ. Or in the course of cross examination, the petitioner has clearly admitted that they have not produced the postal acknowledgement and receipt also. I am a third party. I am suffering. Also,
Your check is bounced antala. Dishonored.
I am for R1.
Who are you?
I am a taxing.
Huh?
I am for R1, sir.
Yaru R1?
ಮಾತಾಡಿ ತಾಳಿ.
Location type.
Claimant or driver?
Claimant.
From after next week.
My lord, in this case, my lord, they have already filed a memo for withdrawal. That means we already deposited the amount.
Senate counsel for the appellant submits
One
the
minute.
amount is.
One submission, please, my lord. ಏನು date ಏನು ನೋಡಿ ಅದು?
Already they have deposited 50% amount in my.
23rd May, 26th May, 23, we have deposited the amount. What is the amount? 2,44,000 we have already deposited.
Next case.
Serial number 4, my lord. I am for the appellant.
Hmm.
The respondent number 1 is the owner of the vehicle. The liability fixed to the respondent number 2. Find the dispense notice. Respondent number 1, my lord.
Notice to R1 dispensed.
And my lord, the insurance company has filed one more appeal.
Body number.
5157 of 23.
This matter along with
This appeal, my
MFA number.
5157 of
57 of 23.
kindly post along with and date may be fixed.
All next week.
Sriram Babu, yeah, I'm appear for appellant, my lord. I am filing memo for withdrawal of the appeal.
Settled.
Case of injury.
All right. Memo file ಮಾಡಿದೀರಾ?
Yes, my lord.
All right. Learned counsel for the appellant has filed a memo seeking withdrawal of the appeal. Placing the memo on submission of learned counsel for the appellant, this appeal is dismissed as withdrawn.
6, Shokil Patil.
I am for appellant, my lord. Claimants also filed one more appeal, my lord. 1601 of 2024. Name may be shown on Nagraj M. Advocate has been filed, my lord.
Week's time granted. Needful done notice to R1. List this matter along with MFA.
1601 of 2024.
Yes.
Number 7. M. Srinivas Reddy.
Fee subsection is, wakalat is signed as well as the application, ಒಂದು ಇಂಗ್ಲಿಷ್ ಒಂದು ಕನ್ನಡ ಅದನ್ನ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ. ಪಿಟಿಷನರ್ ಸೈನ್ ಬೋತ್ ದಿ ಸೇಮ್
ಇನ್ನೊಂದು ಉರ್ದು ಅಲ್ಲೂ ಸೈನ್ ಮಾಡ್ಬಿಡಿ.
ಮಾಡಿದ್ದಾರೆ.
You sign one in Kannada, one in English. What does that mean? Which one has to be there? You will say this is not my signature. I did not authorize Srinivas Reddy to file wakalat. ಅವಾಗ ಏನ್ ಮಾಡ್ಬೇಕು? You have to maintain one signature.
ಇಲ್ಲ ಅವರೇ ಸೇಮ್ ಪರ್ಸನ್ಸ್. ಸೇಮ್.
It is your difficulty, sir.
I will get the better affidavit to file it.
You have to file proper affidavit.
Yes. I will file the better.